The Supreme Court just ruled 9-0 that police can legally enter your home without a warrant. All 9 justices agreed. Every single state in the country is now bound by this new rule. And if you are a gun owner who keeps firearms at home, this decision changes things in a very serious way. This ruling came down from the Supreme Court of the United States on January 14, 2026. Most gun owners have no idea it happened. And the people who do know about it are not fully explaining what it actually means for you and your firearms when police show up at your door, unannounced. You know what is worse than not knowing about a Supreme Court ruling? Finding out about it after it already affected you. Subscribe to this channel right now so you're never the last person to find out when a decision like this drops. Hit that button before we go any further. I cover these rulings every single week, and this one is one of the most important in recent memory for gun owners. Subscribe now, then let us get into exactly what happened. Here's what just happened. The case is called Case V, Montana. The Supreme Court decided it unanimously on January 14, 2026. All 9 justices were on the same side. The opinion was written by Elena Kagan. And what the court decided affects every homeowner and gun owner in all 50 states starting right now. Here is the background. In Montana, police officers received a report about a potential emergency at a man's home. They went to check on the situation and they entered the home without a warrant. The man inside, whose last name is Case, was convicted of assaulting a police officer during that encounter. He fought the conviction all the way to the Supreme Court. His argument was simple. The police had no warrant. The Fourth Amendment to the United States Constitution says your home is protected from unreasonable searches. So entering without a warrant was a constitutional violation. More. It was a strong argument, but the Supreme Court disagreed 9-0. Here is the key legal change you need to understand. Before this ruling, the general legal standard for entering someone's home without a warrant in an emergency was debated. Many courts applied a high bar. Some required what is called probable cause, which means police needed a solid, factual reason to believe a crime was being committed or that someone was in immediate danger. That is a fairly demanding standard. It is hard to meet on the spot. It protects your home from easy intrusion. Now here is what the Supreme Court said in this ruling. The new national standard is called objectively reasonable. Let me explain what that means in plain terms. It means police can enter your home without a warrant if a reasonable officer in that situation would believe there was an emergency. They do not need hard proof. They do not need to meet the higher probable cause bar. They just need their belief to be objectively reasonable based on what they saw or heard. That is a lower, easier to meet standard, and it now applies in every single state in the country. No exceptions. No state can offer more Fourth Amendment protection under this framework when police claim an emergency. Let me break down why this matters so much and why gun rights advocates immediately started sounding alarms after this decision dropped. When police enter your home under this new standard, anything they see inside can be used against you. This is called the plain view doctrine. If they walk in because of an emergency call and they see your firearms in plain sight, that observation is now lawful. Depending on your state and your circumstances, what they see could trigger additional action. And here's the part that shocked me when I dug into this. In states that have red flag laws, also called extreme risk protection orders, or ERPO, a welfare check combined with this new warrantless entry standard creates a very concerning situation. A red flag law allows courts to temporarily remove firearms from someone who is considered a risk. If police enter your home under the new case versus Montana standard and see something that concerns them, whether it is a large number of firearms, ammo, certain behavior, or statements you make, that can potentially start a red flag process. 21 states currently have active red flag laws. If you live in one of them, this ruling adds a new layer of risk to your home, carry and storage setup that simply did not exist at the same level before January 14th. Here is a hypothetical example to make this concrete. Imagine your neighbor, who you have had a dispute with, calls police and says they heard shouting from your house and are worried. Police arrive, knock on your door, and under the new standard decide their entry is objectively reasonable given the call they received. You answer the door with a firearm on your hip, which is perfectly legal in many states. There are several other firearms visible on a rack in your living room, all legal. You are fine. But now, you are inside an interaction with officers who entered under an emergency standard. Your guns are in plain view, and if you say anything that raises concern in a red flag state, the situation can escalate fast. This is not about fear. This is about being prepared. And preparation starts with knowing the rule changed. Quick legal note before we continue. Everything I am sharing here is educational information only. It is not legal advice. Laws vary by state and by individual circumstances. Always consult a licensed attorney before making decisions based on what you hear in a video like this, no matter how accurate the information is. Now here's what most people watching this video are missing about the bigger picture. This 9-0 ruling in Case versus Montana is not the only major unanimous Supreme Court decision in recent months that gun owners need to know about. There are 3 of them, and together they paint a clear picture of a Supreme Court that is actively reshaping how gun laws operate across the entire country. The second ruling came down on June 5, 2025. The case is called Smith & Wesson Brands, Inc. v. Estados Unidos Mexicanos. In plain English, that is Smith & Wesson versus Mexico. The Mexican government sued 7 major American gun manufacturers. They argued that these companies should be held financially responsible for gun violence in Mexico caused by weapons that were illegally trafficked across the border. The lawsuit sought $10 billion in damages. It was a massive threat to the American firearms industry. The Supreme Court of the United States ruled 9-0 that the lawsuit was completely barred. The reason was a federal law called the Protection of Lawful Commerce in Arms Act, often shortened to PLCAA, which was passed in 2005. This law generally protects gun makers and gun dealers from being sued for crimes committed with their products by third parties. All 9 justices agreed that the PLCAA applied and that the Mexican government's lawsuit could not move forward. Why does this matter to you as a gun owner? Because every few years, anti-gun advocates attempt to use massive lawsuits against gun companies as a way to financially cripple the firearms industry. If those lawsuits succeed, the companies that manufacture your firearms go bankrupt. The industry collapses, and your ability to buy, service, and carry a firearm disappears in practical terms, even if the legal right technically still exists. This ruling drew a hard line. All 9 justices made it clear that the law protects gun manufacturers from this type of legal attack. The third ruling is from May 15, 2025. The case is called Barnes v. Felix. This one is critical for any gun owner who could ever find themselves in a situation involving police use of force. The ruling addressed how courts should evaluate cases where police used deadly force. The Supreme Court ruled 9-0 in Case versus Montana that police can enter your home without a warrant under a lower standard called objectively reasonable. This new rule applies in all 50 states as of January 14, 2026. For gun owners, this changes how home carry, firearm storage, and welfare check situations interact with your rights. On the positive side, the court also ruled 9-0 to protect gun manufacturers from billion-dollar international lawsuits and established a new standard for how police use of force is evaluated that benefits lawful gun owners in self-defense situations. The Supreme Court is not finished this term. More decisions are coming, and you deserve to have someone in your corner who reads every opinion, tracks every bill, and explains it in plain English before it affects your life. That is exactly what this channel does. Subscribe right now. Share this video with a fellow gun owner who needs to know about Case versus Montana, and drop a comment below telling me what state you are in. I read every comment, and I want to know how this ruling hits closest to home for you.